Welcome back to the morning show here on Arise News. The Presidential Election Petition Court has dismissed the case filed by opposition parties against the victory of Bola Ahmed Tinubu as President of Nigeria. In a 5-hour marathon reading of the panel's ruling on the substantive case filed by the defeated Labour candidate, Justice Haruna Samani, said the case lacked material facts. He also said 10 of the 13 witnesses who gave evidence were rejected for not being front-loaded with the petition, thus violating Section 285 of the Nigerian Constitution and Section 137 sub 7 of the Electoral Act 2022. Both Peter Obi of the Labour Party and Atiku Abubakar of the People's Democratic Party have vowed to challenge the tribunal's verdict in court. However, it will be recalled that the 2023 election had a record low turnout of 29% in a nation of more than 200 million people, of whom 87 million citizens were registered to vote. Bola Tinubu, the winner of the election, garnered just 8.79 million votes, the fewest of any president since the return to democracy in 1999. Joining us now on the morning show. Joining us now on the morning show as we review the verdict of the Presidential Election Petition Tribunal is Norrison Quakers, a senior advocate of Nigeria. Good morning, Norrison Quakers, and thank you very much for joining us.
It's indeed my pleasure. Good morning, Dr. Abati. Good morning, Rufai. Good morning, Ayo.
Well, quickly, there's no need for any long introduction. We've been on this subject since Wednesday. You are familiar with the details. But first, what are your observations about the reasoning behind the conclusions arrived at by the Supreme Court and the reactions since the judgment was delivered, particularly from the opposition parties, Labour and the PDP, who now insist that they are heading for the Supreme Court, as is their right to do?
Well, incidentally, to be candid with you, some of us are not surprised at the outcome of the election, the tribunal, the judgment of the tribunal. Nothing new has been said. Our law reports are replete with a lot of the issues that were articulated by their lordships. Dr. Abati, you're a lawyer of considerable length of years, or number of years, in the practice of this profession. So you basically also know that pleadings determine cases in court. And therefore, the outcome of this decision is actually a reflection, without necessarily indicting the lawyers who are saddled with the responsibility. A burden is actually placed on a petitioner when proceeding to court to advance the position of your client. More particularly is the provisions of the Electoral Act and also the 1999 Constitution. As you proceed to court, you're meant to have front-loaded all your documents and things that you're going to rely on. You must put forward a credible case to sway the court in your favor. I recall that when the Supreme Court decided the Oyetola and the Adeleke case, it set the ground rule of things to also look out for. Now, before then, there have been other cases. Recall that I think it was in 1979, this issue of interpretation of the provisions of the Constitution as regards a president winning 2/3 of, I think it was 19 states at that time, Chief Richard Akinjide and also, I think, Chief Ibrahim Adesoya were the two leading counsel at that particular time. And when the decision was given, I recall that both counsel were interviewed. And I recall that Akinjide, when he was asked the question of blessed memory, and incidentally both of them are late now, he said he does not see the need to go on appeal. Now, there's a political side to law, and there's also the law itself. Now, as far as he was concerned, it was a decision that could not really be appealed against. But he now went further in saying that if they choose to go on appeal, it's their right, they have money to waste. But the late Chief Abraham Adesanya did say that they were going on appeals. I mean, it's the constitutional right of anyone who feels aggrieved to go on appeal. But if you x-ray the decision, as I have done, because we listened to it and also took notes, it will be a bit watertight to want to go on appeal to challenge it. So for me, it's a very good decision. It's quite laudable. It's also an eye-opener to a lot of us who will be going to court on a number of issues. Like my boss will say, you don't go to court if you do not have a watertight pleadings. You must ensure that your pleadings are really, really tight. What do we mean by that? Your facts and your law must be solid. It must be rock solid before you can access the court and know what you're going to get out of the court with. So those are my own thoughts.
All right. Well, thank you, Mr. Quakers. And for the benefit of our viewers who are not legal minds like yourselves or the lawyers who understand the law of evidence and the likes, I'd like you to break it down for us, because you've said that you're satisfied, at least based on what you've heard, because we don't have a certified true copy of the judgment yet. At least based on what you've heard so far, you're satisfied with the judgment. But in line with what the Labour Party has said, that it doesn't reflect the will of the people, and certain reactions that have come out following that judgment. You know, some people feeling aggrieved. Yes, there's some quarters where there's rejoicing and people agreeing with the judgment. But I want you to share with us, because it's often said that law, when it comes to legal matters, it's not about the feelings of people. It's not about what people see. It's the burden of proof. Can you break that down for us, especially for those who are watching, who are not lawyers and are aghast at the outcome of the ruling?
Thank you so much for that question. First, let's look at it this way. What were the issues that were placed before the court? Essentially, part of it was that the second respondent, that's Bola Ahmed Tinubu, did not win the election based on the majority of lawful vote cast. Now, what is a petitioner in that wise expected to put forward? You're meant to put forward evidence to show that indeed this particular respondent did not get the number of votes that is needed. Now, but the question is, was that done? The answer to that is no, because the court didn't see that credible evidence. Two, you're saying that the sum of $460,000 were forfeited to the state, and therefore it is an indictment. And so for that reason, he must be disqualified. Now, many years ago, Alhaji Atiku Abubakar, who is also a petitioner in his own right, he went to court when there was an attempt to bar him from seeking elective office on the grounds that he had been indicted by the federal government. Because if you recall, the then president, Chief Olusegun Obasanjo, set up an administrative panel of inquiry that came up with a white paper to bar him from seeking elective office. He went to court, challenged that the outcome of the administrative panel, and the court said for it to work, for that indictment to work, it must be a conviction. So that issue has already been determined by the court. So therefore, if you're saying a man was made to forfeit $460,000 and therefore it's an issue of dishonesty, question is, was it a conviction? Now, if it was adjudged in a foreign jurisdiction, right, we have a system in place. If you bring it in, you're meant to also register it to make it effective and applicable to the Nigerian system. So in other words, it must now be within the Nigerian context a conviction. So having not done that, it cannot be sustained. Now, the other issue that was also raised was the issue of INEC not transmitting the results in record time. In other words, INEC not complying with the statute, the enabling statute, which is the Electoral Act. And so LP went to court on that. LP had gone to court at the Federal High Court, Abuja, Justice Nwite, my memory is not failing me, in an attempt to compel INEC to use judicial intervention to compel INEC to comply with the Electoral Act. And his lordship, in his wisdom, ruled that he does not see the need, and therefore that INEC cannot be compelled to perform its statutory duties, that the interpretation of the clear and unambiguous provisions of the Electoral Act gives it some discretionary right. And so for that reason, he threw out the case. Now, LP did not appeal that decision. LP came down again to Lagos and obtained a judgment from a federal high court in Lagos. And in the course of that, APC also went to court to get that decision set aside. So you now have a Court of Appeal decision also on that issue, confirming and aligning itself with the decision of the Federal High Court Justice Wite. Recall that part of what their lordship also addressed was also this issue, that it was like forum shopping. You had abandoned that you had attempted to obtain in the Federal High Court, Abuja, left that, came down to Lagos, got another order which was eventually set aside. So the court also held that this issue has already been litigated. So therefore, it is caught by what we call in law the doctrine of res judicata, amongst other things. So essentially what we're saying is that, look, there's nothing new that this tribunal has pronounced upon. All of these issues have been addressed one way or the other in a number of cases. A particular example, once you're meant to have front-loaded your processes, you cannot bring an application by way of even an amendment, because election petitions are time-barred, they're time-related, they're time-bound. You must file within 21 days. If you bring any other application outside of it, the tribunal will refuse it. And there are cases in that regard. There's so many cases in our law report. There's APC, Amarafa, and a number of other cases.
Okay.
So the question is, why would you take that step
when
you know that the law on this is very clear?
Okay.
Thank you.
Okay, Mr.
Yes.
Quakers, thanks for your deep illumination. Currently, you're a lawyer of, great repute, great standing. You're doing a lot of cases. Like currently, you're the one defending the APC in the Lagos case, and you've been doing all of these filings and all of that. Can you, throw more clarity on the Evidence Act? How should they have filed?
Let me understand you. The Evidence Act, in terms of how should they have filed?
Yes.
The Evidence Act is also very...
Yeah, go ahead, sir. Yes, sir. How should they have filed? Yeah, just throw more clarity.
Okay, the Evidence... Okay, good. All right, the Evidence Act is also very clear. For instance, how do you obtain public documents? You must go to the statutory body to get those documents, and those public documents must be certified. Now, another example I'm going to give to you, for instance, if you study the case of Oyetola and Adeleke, in relation to documentary evidence, the court went further in saying that if you're saying someone is not educated well enough, or someone has presented a forged document, you must give the court the opportunity to compare and contrast the forged document from the original. Now, you recall that Godwin Obaseki had something similar when his result was a certificate from University of Ibadan was challenged. Now, in Oyetola's case, the court said, if you're saying that someone is claiming to have attended a school that he did not attend, you have to subpoena the principal of the school to come and either own the document that the person is putting forward or to deny that document. Was that done in this wise? No. Now, because documents are meant to also be front-loaded, all witnesses to be called in an election petition must be posed to what we call witness statement on oath within a time frame of 21 days, except where the witness is merely coming to tender documents. Even if he's coming to tender documents, the law is apt on this. You must get this person to depose to a witness statement on oath so that you can give the other side the opportunity to cross-examine. But if you list, because there's something called pre-hearing session and scheduling, during the pre-hearing session, you're meant to disclose to the tribunal the steps you want to take, the witness you're going to call, and the documents that they're going to put forward. So if you're going to subpoena the witness for the purpose of just coming to tender a document without being called in evidence, the law has gone further to say, even if you're doing that, that witness must also be deposed. So there must be a witness or no. So the Evidence Act is very clear on all of these issues. Like I keep saying, there's nothing new that this court has pronounced upon that one can consider to be novel. Our law reports are replete with cases in a number of the legal issues that came up in the course of the pronouncement of the court. So compliance with the Evidence Act is simply to look at the provisions of the Evidence Act, right? For instance, Section 84 of the Evidence Act talks about authentication of computer-generated evidence. So how do you do that? You must ensure that you put forth a certificate of authentication to show that the document that you're relying on came from a computer. And the parameters for all of that is also well defined. So as far as I'm concerned, there is nothing new that this case has brought to us by way of elucidation. There's nothing new.
Okay, quickly. I mean, well, the parties, the opposition parties have said they are going to the Supreme Court. Now, without prejudice to what happens there, what do you think are their chances, beyond everybody saying is their right to go to the Supreme Court? What are their chances on the basic issues that they are questioning? And then what do you think of the quality of the judgment? It took more than 12 hours, about 13 hours, the longest perhaps, that we have seen since 1999 or even before then. What do you think of, because some people have been on this program saying, oh, the judgment was delivered with textbook precision. What do you think? And then the chances of the...
I'll start from the...
appellant.
Okay, I'll start from the back. Yeah. Quite frankly, it will be difficult to fault the judgment. It's unassailable, as far as I'm concerned. Perhaps maybe there are things that the counsel to the petitioners have seen that we haven't seen. The aspect of going on appeal, it is indeed a constitutional right that inures to the benefit of anyone who feels aggrieved. But again, there's also the need to sit down. I recall the late Chief Richard Akinjide in one of the sessions that we had with him, where he was telling us about his days in England when he was practicing also in England. He said he went to court to articulate a legal position. And then in the course of addressing the judge, he said the judge kept looking at him as if he had not come across a particular decision of the court. And so he advised him. He said, Richard, have you read this particular authority? And he said, no, he hasn't. So he said, okay, I'll stand down the matter. You go to the library, read it up and come back and then let's talk. So he said he went, the matter was stood down maybe for about an hour or 2 hours. He went to the library, read the report, came back to court, and he asked him, the judge, so where do you stand? I haven't read the report. He said, my lord, I urge the court to discountenance everything that I have said in the light of this decision. I didn't know that there's a new decision on this point. And he was commended. Demola Akinrele, SAN, also did something similar at the Court of Appeal. You know, there are times when you see overwhelming evidence. Once a decision is very clear on the face of it, you ask yourself this question, why am I going on appeal? Because to what end? What will I achieve if I go on appeal? You will remember, I think it was in the Atiku Abubakar case, and I think Yaradua also, where the sage, the then Justice of the Supreme Court, Justice, what's his name again? Who is late now? Nikki Toby, thank you. Right? Nikki Toby, thank you so much. Now, you recall what Nikki Toby said about sentiments and emotions, right? And then the part that really appealed to me was when he now said, I am not saying that the presidential election was conducted exceptionally well. But all I'm saying is that, look, the appellant should have produced credible evidence to sway the court to rule in his favor. Having not done so, there's no amount of sentiments and emotion, and that the court does not exist to embrace sentiments or emotion. And he ruled accordingly. So the challenge we have now is, in the light of what we have seen from the pronouncement of the court, is there any other thing that the Supreme Court will do to reverse the judgment? All we can do is just wait and see. Perhaps applying the doctrine of covering the field. Maybe the field was not well covered, and maybe the Supreme Court would then now look into it and come up with some better reasoning than the Court of Appeal. Mind you, this particular panel, you had a panel of 5. When it gets to Supreme Court, you then have a panel of 7. And let's see what the outcome will eventually be. Perhaps maybe they might have to raise a constitutional issue and then call the court to constitute a constitutional panel, perhaps now to consider the issue of 2/3 of 36 days and the Federal Capital Territory. Maybe that's perhaps the only thing, but the court has also touched that as well. So let's watch, let's wait and see what the outcome will be. What is my position on all of this? For me, I think the decision is watertight, and it's difficult to set it aside. Those are my thoughts.
All right, Mr. Quakers, thanks for sharing your thoughts with us this morning. So, just to mention, and I'm glad you ended on the take on the 25 on the Abuja, sorry, on the Abuja, yes, and Abuja, because for a number of lawyers, even before the ruling of the court, it was quite. A number of lawyers had this, different views with regards to that particular line in the Constitution. So it'd be great to get the Supreme Court's review of that particular judgment, especially as it hasn't sat well with the petitioners. But beyond that, talking about evidences, one of the challenge that we experienced, or that was experienced during the PPC, was access to documents, especially INEC documents, which the petitioners had said that it took INEC quite a while. And because tribunals, presidential election tribunals, are time-bound, it was quite challenging. And we're seeing that play out again, because as at last night, the justices the court hadn't released a certified true copy of the judgment. And so, days are counting, evidence that the court is asking for isn't available. What are the options there? How can we make this better?
Well, thank you so much for that. Let me start by referring to the Chief Justice of Kenya and what she said in the course of determining the election petition between Raila Odinga and Dr. William Ruto. She said the challenge has always been the umpire. Now, the umpire's inactivity or flat-footedness will bring about or generate this sort of animosity between petitioners and the umpire itself. She went further in saying that when the umpire does not conduct the election within the confines of the law, it gives room for suspicion and distrust. Now, what have we seen here? Now, you had a situation where petitioners, right, applied for certified true copy because all of that were also monitoring. But the question is, were those documents eventually, were they made available? Yes, you saw the trial. You had loads and loads of documents that were placed before the court. But were those documents spoken to? Dr. Abati, you also know this. You can't dump documents. Those documents must be spoken to. Those documents must be identified. And that wasn't done. All right. Now, where do we go from here? Part of what we usually do is, in the course of the election, documents that you need to obtain, you obtain them even before the election ends. And I'll give you a particular example. Polling agents, for instance, you also have party representatives at the polls. Now, every document that is given or transmitted, every party agent must also sign, and you're entitled to a copy. Recall that this was exactly the case that the current governor of Imo State relied on at the Supreme Court that made him win, because some of those documents he exhibited were actually obtained from the police, because they are also entitled to copies. So as you go into the polls, you must ensure that you have enough personnel to garner documents for you that you now take before INEC for authentication. Because if you're going to wait for INEC's only document, because you also have these documents that are usually given at polling centers. So one of the ways to also get around is to ensure that you get these documents well ahead of time. Okay. And so what you just do, because election petitions are time-bound and they're time-sensitive, you can't sit back and wait for INEC to make those documents available. Okay. INEC has been accused from time to time of being partisan,
Okay, Mr. Quaker.
Yes, you wanted to ask a question, Mr.
Okay, I hear we need to go, so I have to respect my presence. I just wanted to ask one question about the INEC and document, but I hear we need to go. Have a great day, Mr. Quakers.
Thank you very much, Mr. Norrison Quakers, SAN, for your time with us this morning. Of course, I'm sure we'll have further conversations on the ruling of the Court of Appeal on Wednesday.